The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Neyman and Ditkoff, as you can see. We will be hearing 5 cases this morning. We are hearing argument by video conference due to the ongoing pandemic. Our rules for argument are the same here by video as they are in our courtroom. 15 minutes per side with no rebuttal. The first case you'll hear this morning is number 19-1816, Commonwealth versus Murphy. And we will be hearing first from you, Ms. Fitzpatrick.
Thank you, members of the panel. May it please the court. I'm Shannon Fitzpatrick on behalf of the defendant, Shawn Murphy. This is the case where my client, Mr. Murphy, was arrested for operating under the influence of alcohol after he was stuck in a snowbank during a driving blizzard. Our arguments are twofold. One, there was insufficient evidence for a rational juror to find beyond a reasonable doubt that Mr. Murphy's driving capacity was impaired, and therefore the motion for directed verdict was improperly denied. Our second argument is that the Commonwealth committed prejudicial error by opining during closing arguments about Mr. Murphy's guilt. Regarding the insufficiency of evidence argument, I want to first point out some misstatements in the Commonwealth's brief. The Commonwealth relied heavily on its assertion that Mr. Murphy had driven a vehicle off the road, heavily damaging it. One of these factors was not even proven, the other is misleading and irrelevant. There's no evidence, for example, that Mr. Murphy drove his car off the road. No one testified that he did, and no one testified that there was any erratic driving. And this is not even a reasonable inference. Mr. Murphy went off the road at a curve in the road during a blizzard when there was at least a foot of snow on the road. So I don't believe it is a reasonable inference to say that he drove off the road. There's also no evidence that Mr. Murphy damaged his car by driving into the snowbank.
Sorry to interrupt, but why is that not a reasonable inference that he drove the vehicle off the road if the vehicle is located in a snowbank?
Because of the conditions of the road on the road, why would he? It's because of the road. You can't infer something when there's such an other logical explanation for why he went off the road. There were other cars going off the road that day too, which is in the record. So I
thought there was nothing in the record about any other cars.
There was reference that another car had gone off the road just very close to this location.
Okay. What do you do with what strikes me as the fairly strong evidence that the defendant fell out of the car instead of putting feet first? Why doesn't that kind of wrap this up?
Well, it's an incongruous fact, because one officer remembered it, another officer didn't. The officer who remembered it excused it by saying, well, in his defense, it was snowing.
No, he didn't excuse the falling out of the car. He excused the slipping on the ice. But one of the officers testified he fell like head first out of the car when they told him to get out of the car. Didn't put his feet down, kind of fell out. I think it said head first. Someone describes it, maybe the Commonwealth, as torso first. But either way, it's the Lattimore standard. We have to view every piece of evidence in light most favorable to the Commonwealth. And someone who can't, in a normal fashion, get out of a car might well be unable to operate it as well. And why isn't that the whole ballgame?
Well, I guess I would have to check the transcript, but I do believe that on page 111 of the first transcript, Officer Pillay was defending him almost falling as he gets out of the car.
His feet,
May
not,
have misinterpreted that. Assume it's true. Yes, look at it in the light most favorable to the Commonwealth. It wasn't even remembered by one, and that for other one excused it. It's also incongruous given the other evidence of nothing near this level of clumsiness
Why do you say
anywhere else.
Why do you say it wasn't remembered by the second officer? He testified we had to basically hold him up when he got out of the car. It's at 217, and he was having trouble getting out of the car at 223.
He doesn't remember him falling out torso first.
but one of them does. I mean, it's light most favorable to the Commonwealth.
Yes, so assume that he fell out of the car.
The beer
Torso-
is still cold.
Torso
Score
first.
missing. It
Is that enough?
Hasn't had time to warm up. I mean, I know that you haven't found the bottles, but we're drawing inferences. I understand it's not inescapable, but it's not
Well, I think that is one factor, but I don't know that that is enough, given that the other indicia of so-called indicia of intoxication were weak. We have a lot of red herrings. We have the red herrings of his being belligerent. Anybody would be belligerent, you know, if you're
He
waiting
says
for a
he's a
tow
brain
truck.
surgeon at the General.
And that's another red herring.
Well,
Sarcasm. Why is sarcasm an indicia of intoxication?
if you're wasted and the police ask you what your job is, maybe you say you're a brain surgeon at the General. I don't know.
Well, I think it's speculative. I think it's speculative as to whether that is really an indicia of intoxication. The open bottle of beer, that's kind of meaningless because all it answers is.
I don't think you should be drinking a beer while you're driving your car.
It doesn't mean you
strike me
shouldn't
as
be. You shouldn't be,
meaningless.
but it doesn't mean that drinking a couple of sips of the beer makes you intoxicated. It's not
I agree,
illegal.
but there are
It's not
4
illegal.
missing from a new case, and it's still cold. Now maybe he
Still
doesn't
cold,
have a
meaning-
heater in his car. I don't know, but
I
it's
just
pretty-
don't think that.
still
I just don't
cold.
think that.
4 are gone before it's even warmed up. We don't know for a fact that he drank the other 3, but
You would have to speculate because they weren't in the car.
you would have to draw an inference.
You would have to draw an inference.
I mean,
and
and of course you
that,
put. All right, it's all the
Okay.
facts and circumstances.
Yeah,
I mean, I understand if that's
Okay.
all you have.
I'm saying
Maybe-
that everything here is clouded by the heavy snow, the slipperiness, you know, everything, the tumble out of the car, that I just don't think you can base your whole case on that when all of the other indicia can be explained by or either exaggerated or can be explained by the weather. For example, glassy eyes. Well, there were no red eyes, as you noticed, and that is one of the key indicia is red eyes. And in this case, one officer noticed him, the other didn't, but you know, he was outside shoveling away. I don't think that that is a strong indicia under the circumstances of intoxication. Again, his admission that he had something to drink, we know that he had something to drink. He admitted it, and and that open bottle of beer was there. So that doesn't add any strong evidence to the fact that he was so intoxicated that his ability to drive was impaired. In sum, and I refer to my brief for more arguments, especially my reply brief where I delved into depth as to why each of these indicia do not add up to substantial evidence. But our argument is that they do not add up to enough evidence, that the evidence was too weak for a rational juror to find beyond a reasonable doubt that Mr. Murphy's ability to drive safely was impaired. And I just want to make one note about the Jewett case that the Commonwealth cited. That was a case where they were saying that odor of alcohol and red eyes and stuff were sufficient for with other circumstances to establish guilt. That case is highly distinguishable. There was substantial eyewitness testimony of erratic driving, colliding more than once, and in any case, I don't believe that that is a strong case for suggesting that this case is at all similar. The same with their case of Commonwealth versus etc. That's also highly distinguishable in its facts. Our second argument flows from what we consider to be the paucity of evidence of the impairment to drive. Because that evidence was at best not overwhelming, the Commonwealth's error in telling the jury in closing that Mr. Murphy was too intoxicated to even attempt field sobriety tests was unduly prejudicial, and the error was exacerbated by the trial court's failure to cure the error with a curative limiting instruction. Now, the prosecutor's statement was impermissible for several reasons. It was an impermissible opinion arguing that Mr. Murphy was too intoxicated. It was impermissible because it was the argument that Mr. Murphy was too intoxicated to even attempt sobriety arguments is virtually the same thing as saying that he was too drunk to drive. Now, that type of opinion is not admissible if a police officer were to give it.
Isn't it the prosecutor's job in closing argument to argue that the defendant was too drunk to drive? I mean, isn't that the whole point of the prosecutor's closing argument?
But you can't give an opinion that he was too drunk to drive.
If you can explain.
You can explain the factors, and then you can say, and I suggest that this implies that his impairment was that he was impaired. But to say,
I mean, could you say
he couldn't even attempt to do the test because he was too intoxicated?
Well, why can't you say the Commonwealth argues that he was too intoxicated to drive? Prosecutor can say that, right?
No, they can't give an opinion on the guilt.
Can the defendant say, the defense argues that the defendant is not guilty?
Yes, and this I think goes to the.
Why can the defense give an opinion on guilt or innocence, if that's an opinion of that, and the prosecutor can't?
Well, because the cases say that the prosecutor can't, under my analysis. Pardon me?
They say a police officer can't testify that. I don't know that in closing argument and marshaling the evidence, but I thought that your argument was that there just wasn't evidence to support the statement that the reason he wasn't given the field sobriety test was intoxication. I didn't think you were saying you couldn't argue that if there were evidence. I thought your position was there was no evidence of that. They said that he was belligerent, not that he was drunk.
Exactly. I had that was one of my my arguments, that it was not supported by the evidence. First of all, they made the determination not to even attempt the field sobriety tests before he even got out of the car. They made that before he showed any signs of unsteadiness, or before he fell out of the car, or before he showed any other signs of intoxication. They determined to arrest him because it was too unsafe, and it was too unsafe to give the field sobriety tests. So that is the evidence. That is not enough evidence to say he was too intoxicated to even attempt the sobriety tests. How can you say an odor of alcohol, being stuck in a snowbank, and slurring words, that's enough to show that, and flailing his arms, that was enough to show that he was too intoxicated to perform field exam?
What about having to be helped out of the vehicle and almost falling out torso first out of the car and having to be propped up and held up by the officers? Based on that testimony, why is it not a reasonable inference? Why is what the prosecutor said, rather, not a reasonable inference?
Because if you're looking at what the officers based the decision not to do the field sobriety tests on, you can't look at what happened after they arrested him for making that determination that he was too intoxicated. So
Well,
I'm saying,
Car before they took him out of the car, before they would have given him a field sobriety test. You have to be out of the car to have a field sobriety test.
they arrested him before he got out of the car.
I don't know what you mean by that. They handcuffed him in the car, did they?
They decided before he got out of the car.
They decided. I'm asking whether there was any reason not to. Why couldn't they, once they got him out of the car, have given him a field sobriety test if it were feasible? They could, right?
But they said it wasn't feasible because of the weather conditions. And they had said, I'm looking for the statement where as soon as Mr. Murphy started flailing, they decided to arrest him while he was still in the car.
All right. Your time has expired. I think we understand your arguments very well. Briefed and argued. We will hear now from Attorney Pollock.
Thank you, Your Honors. And may it please the court, my name is Michael Pollock and I represent the Commonwealth in this matter. Your Honors, with regard to the Commonwealth's statement during closing argument, the prosecutor did not misstate the evidence or improperly argue that the defendant was too intoxicated to be given field sobriety tests because of, first, the testimony supported the prosecutor's statement. And second, the prosecutor drew a fair and reasonable inference from that evidence. This is evidence that included argument and belligerent behavior, flailing arms, a strong smell of alcohol emanating from the defendant's body.
I thought the police testified that they didn't give him the field sobriety test because he was because of the weather and because he was belligerent. So is that what the evidence is about why they didn't give him the field sobriety test? Is it a reasonable inference from that somehow that it was actually because he was drunk?
Your Honor, that's correct. The reason why the officers forewent the field sobriety test was because of both the weather, but more significantly, I would suggest, because of the defendant's behavior. And that behavior is consistent or was consistent with somebody who was under the influence of alcohol to the point that they would not be able to safely operate a motor vehicle. So I would suggest, Your Honor, that it's important to look at the testimony and the evidence here as a whole. It was referred to by the trial judge when counsel had originally objected after the statement in closing that the evidence that he had recalled was a bit of a twofer, I believe was the terminology, referring to not only the weather, which certainly we acknowledge, the Commonwealth acknowledges was a factor that day, having been inclement, but it was also due to the behavior of the defendant, and that behavior again was very much consistent with somebody who was under the influence of intoxicating liquor.
Saying that the inference, you're saying that if the behavior that was the immediate cause of the decision not to do the field sobriety test, if that behavior was itself a product of intoxication, that would support the inference made by the prosecutor that it was intoxication that was the reason for not doing the tests.
Yes, Your Honor. I'd suggest that the way that the defendant was behaving when he was out of the vehicle played a significant factor in the officer's decision to forego the tests. And I think that coupled with the fact that there was bad weather even further exacerbated the fact that due to the defendant's current state and his behavior, it was even more so difficult and unsafe, quite frankly, as was testified to by both officers, to conduct those field sobriety tests because they were on the side of the road in inclement weather. and the way that the defendant was behaving would have put not only the defendant, but also the officers in harm's way.
Counsel, so that all makes sense. I wish that had been the argument. But I've never heard of this concept of being too drunk to do a field sobriety test. Obviously, if your field sobriety test can't be administered on people who are intoxicated, you really need different ones. I mean, the guy is too uncooperative, sure, the weather's bad, it's unsafe because of the traffic conditions, I've heard all those, but too intoxicated to have field sobriety tests. I mean, it's such a strange concept. So where does that come from?
Yes, Your Honor, I would suggest that there are certain circumstances where somebody, a defendant, when interacting with officers in a circumstance such as this, where there was belief that they may have been driving under the influence of alcohol, that they could be behaving in such a way that put the officers and themselves in such an unsafe situation as we saw here, that it was not feasible or smart for the officers to conduct that field sobriety test. So in a way, it wasn't necessarily, it was because of the defendant's behavior, again, that was consistent with somebody who was under the influence, that they decided to forego them.
So you're suggesting we should interpret this closing argument to say that his intoxication was causing the behavior that made it unsafe to give the field sobriety test. Is that what you're saying? Am I getting that right?
Yes, Your Honor. The inference that was drawn by the prosecutor when making that statement, and as Justice Rubin had mentioned earlier during counsel's argument, inferences do not need to be inescapable or necessary. They only need to be reasonable and possible. And in the light most favorable to the Commonwealth, I would suggest, Your Honor, that the way that the defendant was behaving was very much somebody who was under the influence of liquor. And that is, again, why the officers were not able to conduct those tests.
This is a preserved claim of error, I gather. So if we find that the closing was an error, do you argue that it was not prejudicial or that it's not part of your argument?
Your Honor, that is part of our argument. If the court finds that the statement was improper, and the Commonwealth is arguing that it is not, the Commonwealth suggests that this is not a prejudicial error because, again, the strong evidence that we saw of intoxication, and this being a fair inference, the statement was in response to the defendant's cross-examination. And it was unobjected to when the testimony from Officer Clay came out that it was because of not only the weather, but he stated, and I quote, "We actually opted not to," referring to field sobriety tests, based on his behavior towards the lieutenant and myself. And it's also important to note, Your Honors, that the judge, even though he denied giving a curative instruction, which the Commonwealth suggests was the appropriate decision there, he did still properly instruct the jury that closings are merely, that they are not evidence, and they are merely an argument by the Commonwealth or the defendant to marshal the evidence and advocate for their position. So again, the Commonwealth suggests that this was not an improper opinion. However, if Your Honors were under the impression that it was, I suggest that it was not prejudicial based on all of these factors. And with regard to the question of sufficiency, Your Honors, sufficiency of the evidence, this is a case, again, where the record shows and the jury found sufficient evidence, an abundance of evidence of the defendant's diminished capacity to operate a motor vehicle. And I had mentioned them earlier in my statement, but with regard to his behavior, the strong smell of alcohol emanating from his body, the glassy eyes, the slurred speech, the difficulty exiting the vehicle, admitting to drinking earlier in that day, and the officers finding an open beer in the center console, that is an overwhelming, the Commonwealth would suggest, amount of evidence. And this case was fully presented and vetted by the jury, and the jury found the defendant guilty. And finally, Your Honors, I would just suggest that when the defendant makes reference to the accident and the damage, that is an attempt to downplay the evidence and distract from what is overwhelming evidence and sufficient evidence that the defendant was under the influence of intoxicating liquor. If there are no further questions, Your Honors, I rest on my brief, and I ask that you affirm the conviction.
Okay, very good argument. We have your brief. It's also excellent. Great job, both of you. Thank you very much. The case is submitted.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by my colleagues, Justice Neyman and Justice Ditkoff. We are hearing argument this morning via teleconference due to the pandemic. The rules are the same as in the courtroom. 15 minutes per side with no rebuttal. The next case we will hear is number 20-485, Commonwealth versus Martinez. And we will hear first from Attorney Beck.
Good morning, members of the panel. May it please the court, Carol Beck on behalf of Nicholas Martinez. This is an appeal from the trial court's denial of a motion for new trial. I would like to first address the issue of the instructions that the jury heard on armed home invasion. The jury heard testimony from both Mark Taylor and Lisa Cofield that they entered the apartment of David Bastarach with his consent, that they walked into the apartment with the intention of buying drugs as they had prearranged. Now, if the jury credited this evidence and further found that at the time of the incident, Mr. Taylor had a knife in his pocket, then I would suggest that the instructions that the jury heard incorrectly led them to believe that this was sufficient to negate the notion that Mr. Taylor entered lawfully.
How do you square your argument with Putnam, specifically Putnam at page 479, which as I read it addresses this very issue?
Putnam, I think the language of Putnam is confusing. And I think that what Putnam is trying to say is that if a hypothetical person enters a dwelling, both armed and with intent to commit a felony, and they are consensually let in, then that consent is negated if the person who lets them in is unaware of either of the two things that are true, that he is armed or that he intends to commit a felony. Because otherwise, Putnam is directly in conflict with the SJC's opinion in Commonwealth versus Marr, which makes it clear that what is necessary to negate consent is an entry while armed in order to commit an assault. And so I would suggest that if someone comes in, as many people carry a pocket knife, it's not unusual to have one on a keychain or to have it in one's pocket, and to suggest that that is sufficient to negate someone's consent to let you in the door. I would suggest.
I thought that was the very argument made in Putnam, and I'm reading from it right now, where this court held Mahar does not require the Commonwealth prove that the occupant has been made aware both that the defendant was armed with a dangerous weapon and that he intended to commit an assault once inside. That is to say, if the Commonwealth shows that either element was not present, then there was no consent.
Right, but I think what Putnam, when they say the other element, I think what Putnam is referring to is the knowledge of the person who's letting them in. So if someone's at your door and intends to enter to commit an assault and they have a knife, then you may know that they are in the habit of carrying a knife. But that one thing that would negate consent because you were not aware of the other. And that's the intention of the or phrasing here. Mahar makes it very clear when they talk about Commonwealth, the facts in Commonwealth versus Fleming, and say that this is not what the armed home invasion statute is intended to encompass. And Fleming is very similar to the facts in this case. A man goes into a dwelling with a knife in his pocket. He visited there frequently, and he had sort of an implied consent to enter from numerous previous entries. Once he gets in there, he gets into a fight with the residents and ends up assaulting someone with that knife. And what Mahar says is that this is not an armed home invasion. This is not what the statute is intended to encompass because the defendant did not enter the building with the intent to commit the assault. That intent arose later once he was inside the building. I'd like to turn to the issue of defense of another. The jury was instructed that before Mr. Martinez could come to the defense of Mr. Taylor, he had to first avail himself of all proper means to avoid physical combat. Now, this is language that was explicitly disapproved in Commonwealth versus Allen.
But that's after this case, right?
Yes, it is. Yes, it is.
Ineffective assistance claim.
I'm
So-
sorry, Your Honor?
This is an ineffective assistance claim, right? This is not a direct appeal where Allen was decided pending the appeal and we would apply it. This is a claim of ineffective assistance. So wouldn't we have to find that a lawyer prior to Allen being decided and after Hakala was decided fell below what might be expected of an ordinary lawyer by not raising a claim that hadn't yet been announced by the SJC?
Yes, Your Honor, but I don't think that this is a particularly complex legal point. And
I don't think it is either, but Hakala permitted an instruction about this. I don't know why, but they at least said, maybe they indicated there wasn't so great or whatever, but they said, oh, the jury wouldn't understand instructions like this that way, right? So.
Your Honor, I think that under the facts of this case, where when Mr. Martinez, according to the testimony of Mr. Taylor, because we're looking at the facts in the light most favorable to the defendant for jury instruction questions, that when Mr. Martinez entered the living room, what he would have seen was Mark Taylor with one person on his back with their arms around his neck, while David Bastarach, much taller, much heavier than Mr. Taylor, is beating him on the head with a pool cue. And on the facts of this case, I would suggest that trial counsel should have realized that the language to avail himself of all proper means to avoid physical combat should have been objected to. And
You have to, okay.
Aren't there a number of areas in which maybe we disagree with the law, but we have to follow precedent? So I guess, another way of asking this question is this. Can you cite to me a case in which an attorney has been held to perform measurably below that of an ordinary fallible attorney for failing to anticipate a change in the law?
No, Your Honor.
But I don't think that's quite, I read your argument or hear your argument to be a little different from that. I gather what you're saying is something like, even though it wasn't an erroneous instruction at the time, see Hakala, it's an idiotic instruction, or it weakens the case of self-defense substantially, and it should have been objected to just on logic grounds, even though it may not have technically been in error, something like that.
Yes, Your Honor, because on the facts of this case, there's no proper way to give meaning to this language. other than to suggest that the defendant should have turned around and run, which the trial court judge found the jury could not have believed, or that somehow this was an indication that Mr. Martinez couldn't defend Mr. Taylor unless he had.
Of course, Hakala, as in Allen, the SJC doesn't even say it's overturning Hakala, right? It sort of says, well, because that would be so foolish, we don't think a jury would understand it that way, which might not be the way I'd have decided. Judge Ditkoff has.
Counselor, would you characterize the instruction given here as substantially the same as Allen or substantially different?
I think the instruction here in its relevant respects is substantially the same as in Allen.
And let me ask you another question. In this case, the jury convicted the defendant of armed assault with intent to rob. So in light of, and you have no problem with any instructions on armed assault with intent to rob. So in light of the fact that the jury believed that this was an attempt to rob, how can we find a substantial ground of defense was lost by these instructions that all assume the jury did not find an armed assault with intent to rob?
Because, Your Honor, and the failure of trial counsel to request an instruction on use of non-deadly force in order to recover personal property could have led the jury to conclude that at the point when Mr. Taylor reached for Mr. Bastarch's hand to grab the money out of it, that was unlawful and was sufficient.
I'm not sure I understand that, because the instruction here was that robbery required you to deprive someone of his or her property permanently. So if the jury believed the testimony of the defendants that it was not the victim's property, but in fact their own property, they couldn't have convicted of the armed assault with intent to rob. So why is that wrong?
So I cannot, I'd suggest that we shouldn't intuit what conclusion the jury drew from Mr. Taylor reaching for that money.
Well, we don't have to it. We have a verdict that the jury found that he assaulted him with the intent to rob, which meant the intent to permanently deprive him of his property, right?
Yes, and I would suggest that because he had a knife in his pocket, because he reached for Mr. Taylor once Mr. Taylor had control of the money, and because the jury was not instructed that he was entitled to do so, I mean, I understand Your Honor's arguing that, well, they must have known that that money wasn't Mr. Bastarach's at that point, therefore not a robbery, but I'm not sure that that's a fair conclusion to draw in the absence of all these instructions.
I don't understand your argument about the right to defend property anyway. The amount of force you're allowed to use to defend property doesn't include deadly force. So even if they had been instructed that Mr. Taylor was, at least if they so found, could have used some force to try to get his money back, they were also instructed that the defendant could only use the force that in defense of another anyway, the force that was necessary, that was lawfully authorized for the other person. And instead it's deadly force. I don't get it.
I mean, what I would suggest, Your Honor, is that on the instructions given here, the jury could have found that the entry into the apartment was unlawful because he had a knife in his pocket. So that's the first part of the instruction on armed home invasion. The apartment was occupied. The defendant had a weapon. And so the last one is, was there a use of force? Not was there a use of deadly force, was there a use of force? And so the jury may have found armed home invasion at the point when Mr. Taylor grabbed at Mr. Bastarach's hand under the instructions that were given. And so it was important for the jury to understand that however the escalation happened and who commenced the use of deadly force, that Mr. Taylor, on his version of events, was entitled to an instruction that he had a right to do that.
I think I'm missing something. Deadly force is what was used.
Deadly force is what was ultimately used. The question isn't whether a defense of personal property instruction will excuse a stabbing, because obviously it will not. It will not. But the question is whether could the jury have found armed home invasion based solely on Mr. Taylor's grabbing his arm? Because if they could, and they were given a joint venture instruction, then the defendant is impacted as well. I'd turn briefly to the issue of the knife that was introduced into evidence. It's clear from the trial record that the prosecutor contacted counsel the day before, informed them that he was going to try to get this knife into evidence.
Counsel, your time is short, so I would like you to jump right to the question. All the jury heard was that a steak knife was collected from the apartment of the co-defendant. Why is that so prejudicial that it deprives someone of a substantial ground of defense?
The knife was introduced into evidence. They would have seen the knife. It's a 10-inch knife. And I would suggest that it filled a gap in the Commonwealth's case, as I lay out in my brief, because there was no description of the knife found on Mr. Martinez used. And so the jury could have, during the course of the testimony on the assaults, had this knife in their mind and been thinking that must have been the knife. And given that, more compelling instructions should have been given when the knife was taken out of evidence.
If there are no further questions, although if there are, I'm happy to. No? All right, your time has expired. Thank you very much for an excellent argument, Attorney Beck. We will now hear from Attorney Haran.
May it please the court, my name is Donna Marie Hare, an Assistant District Attorney representing the Commonwealth. Going to the first issue, Your Honor, well, the motion judge here properly denied the defendant's motion for a new trial while the defendant has failed to establish that his counsel rendered ineffective assistance or deprived him on otherwise substantial ground of defense. Going to the first issue, Your Honor, this whole case is controlled by Commonwealth v. Putnam, which I'm very familiar with. This exact claim was raised in Putnam. This exact instruction was challenged. And this court in Putnam found that it was a correct instruction, and SJC denied further appellate review. This court also found, as I think Justin Neyman pointed out, that it said that Mahar does not conflict with this case, that in order to negate consent, the Commonwealth would have to prove that either the person giving consent was unaware that the defendant was armed, or that they planned to commit a crime or assault once inside. I would suggest that that is completely controlled by Putnam, and that this court should affirm it based on that. If there's no questions on that issue. Turning to the second issue, the judge here correctly instructed the jury in defense of another, and the defendant failed to establish that counsel rendered ineffective assistance of counsel by failing to object. Moreover, I would suggest that even if this court were to find ineffective assistance, the defendant wasn't prejudiced because he was not entitled to the instruction, even in light most favorable to him. As this court noted, Allen came down after the defendant's trial.
Okay, but it's a crummy instruction, right? It's obviously, even before Allen, I mean, I can't say what everyone would do, but a lawyer with her thinking cap on, or his, would look at this and say, why is it saying they have to avoid physical combat? Of course they can avoid physical combat when they're defending another. They're not the one who's in the combat. They're trying to, they are going in deliberately when they could just stand by. I understand that it's, been used before, but it's a crummy instruction, right?
I wouldn't necessarily say that, Your Honor. First of all, to the extent that it suggests there's a duty to retreat, that's where Allen found there was a problem in the instruction. And they suggest
that it says you have to, what is the phrase, avoid physical combat. That's
I'm so sorry to interrupt you, Your Honor. I apologize. But the part of where they say that it incorporates the language that you have to use all available means before, Allen found was proper. It was the part where it could suggest that you had a duty to retreat that Allen found was confusing and flawed. But they affirmed in Allen.
Wouldn't retreating be a way of avoiding physical combat?
Before employing deadly force, you have to use reasonableness, which they have affirmed in that portion of the thing. And because it's so obvious, they said that you can't have defense of another and a duty to retreat. They found it wasn't prejudicial. And I would suggest this case is just like Allen, where the judge did not instruct that the defendant had a duty to retreat, where the judge repeatedly instructed that the Commonwealth bore the burden to prove beyond a reasonable doubt, but the defendant did not act in defense of another and did not act in self-defense.
Can I ask you about the steak knife?
Sure, Your Honor.
I'm going to change the case up a little bit.
Okay.
Hypothetical. We know that sometimes in a murder case where the defendant has thrown away the gun and no one has seen that happen, so there's no gun at all, that juries, it's harder to get juries to convict when there's no gun found. So let's imagine a case where near the beginning of the trial for a murder, the judge lets in, we can say de bene, but the jury doesn't know what that means. It just lets in evidence a gun that was found nearby. What is this, officer? Oh, this gun, I recognize that. I found that in the bushes outside the building where the murder occurred. Okay, thank you very much. And the gun just sits there, wherever evidence sits during the trial, on a table or whatever. But there's a gun. And now they listen to all the evidence of the whole case. How someone was shot, how blah, 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 this and that, da, da, da. And then at the very end, no one's mentioned the gun anymore. The defense counsel objects and the judge says, that gun, I'm striking that from evidence. Ignore that. You're not to assume that that has anything to do with this case. Don't you think that might nonetheless, the fact that they thought during the whole course of the trial that this must be the gun, why else is it on the table there? You don't think that that might prejudice someone?
In that hypothetical, it may, but we have a totally different case here, Your Honor. First of all, there was a description of the knife that Martinez used. The two of the victims described it as a wooden knife with silver. They described it differently. Second of all, this knife was found at the co-defendant's apartment, not hers. Third of all, this is brought in an ineffective assistant counsel claim for failing to strike it, and that is belied by the record. Defense counsel immediately objected to its admission. So this claim is brought under the ineffective assistance for failing to prevent the knife from coming into evidence, and that is belied by the record. The trial attorney objected immediately when the prosecutor said they were going to offer it. He argued that he said during the beginning arguments that he didn't think human blood, he didn't think that was accurate. He didn't think it was human blood on the knife.
The prosecutor, he didn't know. And maybe, I don't know for sure, this is another tricky part of, an obstacle for your sister to overcome. But he didn't know. And maybe if he had said, no, Your Honor, I have the lab report here. There's occult blood. They can't even tell what species it's from on the serrated edge of a steak knife that might be used to cut something with blood in it, like a steak. And the judge, maybe he'd have admitted it to Benny, but I don't know, I wouldn't have, right? Like, well, what are we talking about here?
Well,
but instead, there it is, it's sitting there, and now the burden is a little different, or may feel a little different. The judge feels like he's admitted it, and and then the prosecutor says something utterly meaningless, I think, right? Which is there's other circumstantial evidence. Now, maybe that would have, I don't know.
Again, this is in terms of ineffective assistance of counsel.
Yes.
The counsel objected, said he didn't believe there was human blood in the steak knife. Then at the next available opportunity, because then the witness came and testified, co-counsel, who was took over responsibility, given it was his client that the knife was found, told the judge that the lab report said it wasn't human blood. The judge then, for whatever reason, said she was going to strike it, but would allow the Commonwealth a little leeway, and then ultimately struck it and instructed, it gave a curative, strong instruction for the jury to disregard it. So in terms of ineffective assistance of counsel, I don't think she's met that burden of what counsel could have done. And I do want to alert the court, on Friday, the co-defendant's direct appeal was decided by this court. It's an unpublished decision, but it doesn't even have a Westlaw tag yet, but it's 19P0056. And a similar issue when that was raised, and this court found that the instruction the judge gave, the curative instruction regarding the steak knife in regards to Mr. Taylor, was a proper instruction.
Counselor, can you give me that again? 19P.
Sorry, it was 19P0056, Commonwealth v. Mark Taylor, which was the co-defendant in the case. And this was his direct appeal. And the steak knife was also raised in that appeal. And this court, in an unpublished decision, found that the judge instruction was proper. The curative instruction to totally disregard the steak knife and to have no part in your deliberations was a proper curative instruction.
Going back to the knife, is this a case where the prosecution was waiting for additional testing on the blood on the knife at the time that it was admitted to Bene, or was the prosecutor's case what it was at the time of trial?
I'll be honest with you, I do not know why the prosecutor did what he did, and I think he had an overwhelming evidence in this case, given the witnesses' testimony, the victim's testimony, the cooperating witnesses, the surveillance, the victim's DNA found in the car. Why he sought to omit this steak knife, I'll be honest with you, I don't know why he did, but I think it was such minimal testimony and it was unnecessary, and giving the overwhelming other evidence that he did present, I don't think the defendant was prejudiced by it in the curative instruction given by the judge. I do not know why the prosecutor, what they were thinking, or he clearly thought there was human blood on it, and then based on his, was clearly wrong in that thought. And then he also was trying to argue based on the surveillance video, but that also clearly didn't pan out. I don't know why, I'll be honest with you, Your Honor. If there's no further questions, the Commonwealth will rest on its brief.
Okay, I see none. Thank you very much. Excellent argument, Attorney Herron, and excellent argument, Attorney.
The case is now being recorded.
Good morning. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justices Neyman and Ditkoff. We are holding this argument by teleconference in light of the ongoing pandemic. The rules for argument are the same as they are in our courtroom, 15 minutes per side with no rebuttal. The next case is number 19-1147, Commonwealth versus Mullen. And we will hear first from Attorney LaRouche.
Good morning, members of the panel. May it please the court. My name is Sarah LaRouche and I represent ERIKA Mullen in this direct appeal. The trial court erred in denying Ms. Mullen's motion for a required finding of not guilty because there was no evidence that once Chambers took out a knife and began stabbing Estrada, that Ms. Mullen did anything to participate to ensure that that stabbing was successful. Further, there is no evidence that Ms. Mullen shared with Anthony Chambers the requisite intent for murder, which of course is malice. It was incumbent on the Commonwealth at trial to zero in on the climactic moments of this fight. And this is really a subset of the joint venture case law. So it's not sort of general joint venture cases. We're really looking at cases like Lugo, Samito, Sexton, and Avery. So these are cases that tell us in this kind of a situation where you have a spontaneous altercation, we really need to look at what specific actions the alleged co-venturer, the defendant, took to assist the principal.
I guess.
I'm sorry.
Judge, you.
Well, what about the evidence from the eyewitness who testified that it was the defendant doing the hitting and that Chambers was trying to pull her off and that she was striking him and wrestling him and getting the better of him, and I think striking to different portions of the body, which may or may not be consistent with where the knife wounds were? Why does that not answer at least part of the issue?
As I said in my opening, I really do not believe here that there is evidence that Mullen stabbed Estrada.
Can I
I
say
get
that? What about where she says in her statement or interrogation, whatever it is, to the police, where she volunteers that while she was punching him, before Chambers arrived, she heard him make a noise like he'd been stabbed.
Like he'd been stabbed. Well,
She says she kicked him in the groin, the nice place that she knows, and she later on says it was the groin. You know, she does not admit in her statement to police the next day that she stabbed him.
Of course not, but I'm saying, why couldn't a jury draw an inference? Here's this person. She doesn't know what evidence the police have. We all know these, well, for whatever good or ill, we know these police tactics of pretending to know more than they know to get people to admit things. And in this case, she doesn't know what they know, but concerned that maybe somehow they know that the actual stabbing took place before Chambers arrived. She says she doesn't know what happened, but she heard him make a noise like he was stabbed. Why isn't that just, I mean, in Lattimore standard, why isn't that enough? I understand she has no blood on her, but I'm not sure that we can say that that absolutely precludes her being the stabber. It's curious, to be sure.
My position is that the climactic moments here are the moment after which a knife is taken out. Estrada does not die from punches or kicks. He dies from 5 stab wounds. We have, in cases like Lugo, Samito, and Sexton, we have very specific details about what a alleged co-venturer does once the deadly acts start happening. And, you know, we just don't have that here. That aside from her statements, which, you know, her admissions don't rise to the same level as the admissions in, say, a case like Javier, where you have a defendant that's overheard making a statement, a threatening statement to a victim, saying, I'm going to kill you, and he throws a knife at the victim. This is a totally different situation.
She was going to ruin his whole world.
Her statements are consistent with the...
No, it's the inferences have to be drawn, you know, in favor of the Commonwealth. I mean, the part that I have a hard time with on the joint venture, I mean, so that's some of, I've been talking about, what if she is the stabber? Let's say that the boyfriend is the stabber. We don't know that the stabbing occurred during this 50-second period when she was away from the fight, right?
No, we don't. But the point is, there is no...
If they're beating him up together, which happens a lot, right? People are in groups having a fight or beating someone, and someone of the group pulls out a knife and stabs the defendant, the victim. You think that is never enough by itself to hold the other people who were also beating him liable for murder?
The case here is different. We have nobody saying anything about seeing a knife come out. It would be speculation.
did come out because there are stab wounds. So I don't know what knife, I don't know how, no one seems to, but one of these two people, I think it's fair to say, Chambers or Mullen, murdered this fellow or killed this fellow.
And we must know specifically what this defendant did to aid Chambers in that effort.
But so I've asked you about when two people are beating someone up, both punching him in the face and head, and one of the two pulls out a knife and stabs him. What more do we need? That is enough.
That's enough. But we don't have that from SHAWN.
Well, I'm not sure. Why don't we have that?
Because he doesn't say anything.
Hypothesizing that the stabbing took place during this 50 seconds. But we know that both of them, there is evidence, put it this way, that both of them beat this guy, right? She says Chambers punched him in the face, right? And she says, I punched him in the head and kicked him in the groin. I was so enraged, it triggered me. I told him I was going to ruin his whole world. So at least at some point during this altercation, there's evidence that the jury could have believed that the two of them were beating him up together, right?
Right, but SHAWN says that Chambers didn't do much of anything. And
your client says he stabbed him.
Right.
That's not much of anything. That's stabbing.
Right, but I'm saying the only person who sees this incident, the only person who the Commonwealth put on to testify about what happened is SHAWN. And to put a knife in anyone's hands based on SHAWN's testimony is speculation.
Your client says that Chambers stabbed the victim. That was played to the jury, right?
Yes.
And she says he admitted it to her.
Yes.
Okay, so let's say that's the knife, and I don't know if it is, but let's say now we have Chambers stabbing this guy during a fight that she's participating in. You hypothesize that there are 50 seconds when she has walked away and come back. You hypothesize that she no longer wanted to beat the guy up, although she comes right back. I guess I'm just not sure why this isn't a regular case of two people beating someone up and one of them stabs the person.
Because SHAWN says fists. SHAWN doesn't say I see someone stabbing or doing stabbing motions.
Let's say he didn't exist. Let's say there was no eyewitness. Okay? Now all we have is this ridiculous video that's almost imperceptible what's going on, and a statement to the police by your client that the stabbing was done by Chambers. Right? Isn't that enough?
The Commonwealth's burden is to prove what she did. So there's a moment. There's a moment when we have a fist fight and a kicking fight. And there's a moment when a knife comes out. And it was the Commonwealth's burden to put in facts, put in evidence about what specific acts she did after the deadly action starts. So in Lugo, Samito, and Sexton, you have, the head getting bashed into the ground, and then the defendant continues to stomp. You have somebody beginning to stab, and the defendant continues to punch and kick. But here, after the knife comes out, SHAWN doesn't tell us what precisely she does.
Yes, I've asked you to imagine that, let's say the jury just disbelieved everything he said. They know about eyewitness testimony and how unreliable it is. So they discount everything that guy says. But they know there's a fight in the park at the end of which this guy is bleeding to death. Right?
Yes.
Okay, so one of these two people, Chambers or Mullen, stabbed him. You agree with that?
Yes.
Okay. So if they're both, maybe I'm just repeating myself. I don't understand why this isn't like any other two-person fight where someone gets stabbed.
Well, if we're looking at just what she said, she says that she was scared out of her mind. She hits and kicks him. Chambers comes over. She has no idea, and there is not a shred of evidence that she knew that he had a knife. He tells her to leave. She walks away. He does whatever he does. She realizes he's not with her. She walks back, and they leave the park together. That's what she says. She says that after he took out the knife and decided to take these deadly actions, that she did not do anything.
She doesn't say when he took out the
Consistent with joint venture.
because she doesn't know when he was stabbed. All right, I don't know.
Counselor, can I ask you about these 50 seconds?
Yes,
At minute 35? I
yes,
mean, I've looked at it many, many times.
yes.
You see one of the little black splotches going away from the other two black splotches. Why do I have to believe, why does the jury have to believe that the black splotch that goes away is the defendant?
The jury doesn't have to believe that. My position is the Commonwealth didn't give enough to understand what she did. Their bucket of proof is empty about what she did. And on the other hand, not weighing conflicting evidence, just noting that in fact, you know, the police tell her, we have 20 cameras of the park. You tell us what happened. And she tells them, and, you know, as she's talking about this part where she moves away, she says, you know, you'll see in the video, I wasn't running. I didn't run away. I was just walking away. And the police are saying, yeah, that, you know. And so my position is that the video, no, the jury does not need to take that in the way that I've described. But in fact, the video is consistent with her statement to police that she moved away, that she then moved back, and that she learned later after the fact that Chambers had taken out a knife and stabbed Estrada. I, of course, recognize that that video is incredibly grainy. It's incredibly dark. It is not, you know, perfectly clear what's going on. But my position is that, in fact, it supports her statement to police the next day that she removed herself and she returns. If I may address malice, there's no evidence here.
So why does the Commonwealth have to prove malice to get a manslaughter conviction?
In order for the to survive the required finding of not guilty, the Commonwealth had to prove malice. There had to be enough evidence to get them over that threshold, and without that,
Why is malice an element of manslaughter?
it is not an element of manslaughter.
Well, why does the Commonwealth have to prove that to get a manslaughter conviction?
The Commonwealth doesn't, but in order to survive the required finding of not guilty, the Commonwealth needed to show malice.
I don't understand that. If you don't need to show malice to get a manslaughter conviction, how can the judge do a required finding of not guilty on manslaughter because they didn't prove malice?
Well, I agree with you. But malice is absent here. There is no evidence that she acted with malice.
Let me ask Justice Ditkoff's question a slightly different way. Defendant moves for a required finding of not guilty in this case. Had the judge said, well, I'll allow it as to so much that alleges murder 1 and murder 2, but I deny it as to voluntary manslaughter, and that part of the case can go forward, would you agree that you don't have that issue present in this case?
You can answer the question.
Yes, I agree with that.
Okay. Thank you.
All right, excellent argument. Thank you very much.
Thank you.
We will hear now from Attorney Oftring.
Morning, may it please the court again, Susan Oftring on behalf of the Commonwealth. The Commonwealth asks that this court affirm the defendant's conviction of voluntary manslaughter when the trial judge properly denied the defendant's motion for required finding of not guilty. The evidence has to be looked in the light most favorable to the Commonwealth with all reasonable inferences drawn in favor of the Commonwealth. And I would submit that my sister's argument is basically picking and choosing favorable statements that the defendant, in the multiple versions that she gave police, was suggesting was more favorable. To look at this in the joint venture texture, you look at not just the climatic moments, but to know the defendant's intent in her knowing participation in the commission of the crime charge. I think the jury properly and the judge properly looked at the entire circumstances. We had the video, which was the clear portions of the video before the episode in the park, where you see the defendant's demeanor, and she admitted to police eventually. She was upset, she was angry at some point, she looks like she's going to punch a wall. You then see them as they approach the park again, and the defendant admits she's upset, she's crying, and she goes into the park alone. And I would agree with Justice Rubin and the other justices, you know, the video, I think everyone wishes it were clearer, but the reasonable inferences based on Mr. Schott's testimony, the version of events as the defendant gave to police when she was confronted with the fact that the police knew she was lying, that she wasn't there and she wasn't with who she was with and she didn't do what she did, now says, okay, yeah, that was me. So you take all that evidence, especially, again, those videos, you don't see a knife. I agree with that. And Mr. Schott doesn't see a knife.
If you don't see enough, why isn't your sister right that we have to speculate to know whether she in fact was, you know, had the requisite intent and participated in the crime when it happened? We don't even know when it happened. Maybe it happened during the time she had walked away. She wasn't even standing there. How can, and the jury has to find beyond a reasonable doubt. And I have no idea. You know, I've looked at the record here. I have no idea, and watched the video. I don't know when the guy was stabbed. I find lots of the facts sort of curious, but you know, she has no blood on her. There's no blood on her knife, which doesn't necessarily mean she thinks maybe he was stabbed with his own knife. Look, I have no idea what happened. There isn't another knife. It's true that we don't have the shorts or whatever it was that Chambers was wearing, or pants. Maybe they had blood on them. I don't know. But assuming, I mean, how do we know? Right? I can tell you 10 stories. Why isn't it speculation?
Respectfully, Your Honor, it's not speculation. The judge properly denied the motion for required finding, again, viewing it in the light most favorable to the Commonwealth with reasonable inferences. And it's not speculation when you look at the video in the images of where they are, knowing what the defendant told police. She went and sat under a tree, that the defendant approached her from a bench. You see that bench, I'm sorry, the victim approached her after sitting on a bench. I agree to the extent you can. If you look at the video multiple times, unfortunately you'd have to, but you see the defendant going into the park and sitting down, and she agreed to all this. The victim comes up, she says he has a knife, and you see her jump up. You can see that in the figure, and you see those two figures coming together, retreating, coming together. She goes back, she comes back. At that time,
punching someone or kicking them isn't stabbing them, right?
Even if she wasn't stabbing him, even if she wasn't at that time, Chambers is not in the picture. Chambers was still at the bus stop, and she said it, and the video supports it, and Mr. Schott even supports it. So even if she wasn't stabbing him at that time, and I would put an asterisk because I think the evidence, again, in the light most favorable to the Commonwealth, and Justice Rubin, you pointed out, she didn't know that during the interview that the defendant was stabbed, but she said, well, I kicked him or punched him, and he went, ah. Later on, she says he bent over. It's as if he got stabbed when he made that noise, and Chambers wasn't around. So reasonable inference is she went so far, except she wouldn't say she had the knife, is that's when she stabbed him. He says, bends over, and she's the one who said Chambers wasn't even there.
But that may be sufficient. But I am asking about the joint venture theory. And I'm trying to figure out how we're supposed to do this joint venture thing. Because I'm sure lots of times violence takes place behind closed doors. We don't even have a video or an eyewitness. But there's two people who walk out and a dead body that's left inside. And I'm trying to figure out how you get to beyond a reasonable doubt. In a way, that's what this is like, right? Because that video, you can't see who's stabbing or when, or, you know what I mean? So are they both guilty? Is only one of them guilty? How do we know beyond a reasonable doubt that there was this shared intent or willingness to assist? How do we know that?
Well, beyond a reasonable doubt is what the jury's function. The claim on appeal
No,
is,
beyond a reasonable doubt is the Commonwealth's function.
no, I'm saying the claim on appeal is the judge erred in denying the motion for required finding of not guilty. That's and even he said it, it's a low burden compared to beyond a reasonable doubt. So if the issue is, did the judge err in not allowing the required finding of not guilty, it's a Lattimore standard. We're not at beyond a reasonable doubt. The Commonwealth didn't have to prove beyond a reasonable doubt at the time of required finding of not guilty.
It had to be
That
sufficient
being,
evidence in the record to support a finding beyond a reasonable doubt. Right? You have to have sufficient evidence in the record to support the jury's finding. Otherwise, you don't send it to the jury.
I agree, but the judge in his findings views the evidence in the light most favorable to the Commonwealth. And the Commonwealth is that one of the two stabbed the victim. And I don't even think that's disputed. I think it's just which one did, but the Commonwealth doesn't have to prove which one did. The Commonwealth just has to prove there was a joint venture, the defendant was a willing participant and shared the intent with Chambers.
Okay, what is the evidence that shows beyond a reasonable doubt that she shared the intent and that she just wasn't just someone who wanted to beat the crap out of him, but would never have wanted to kill him?
Well, she just beating the crap out of him, I think even in and of itself without the knife is enough. And the case I would cite for that is the Commonwealth versus Chim, CHHIM. I think that's in my brief. She doesn't need to, we don't have to prove that she had the knife in her hand. It should have that intent to kill the victim. And her testimony, her statements to the police, I wanted to ruin his world. I was the primary aggressor. I punched him, I kicked him. She grabbed his shirt. And all this is corroborated by, again, partly by the video, but more importantly by Schott, who says the most he saw Chambers do was try to pull her away from the victim, and she resisted and went back. So to me, the evidence, again, in light most favorable to the Commonwealth, is not only did she actively participate in this joint venture with the intent to kill the victim, but more likely than not, she was the one who had the knife based on the evidence. 12 hours between the time of the crime and between the time she was interviewed by police. There was testimony that she and Chambers went back to the apartment, went into the bathroom. They could have done anything with the knife, but the Commonwealth suggests that the evidence was sufficient to support the crime of first degree or second degree murder, and the judge properly denied the motion for required finding of not guilty. And clearly the evidence is sufficient to support what the jury returned as a verdict. And if there's no questions, the Commonwealth will rest on its brief.
Seeing none, thank you very much, both of you. Excellent arguments.
The case is being recorded.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I am joined today by Justices Neyman and Ditkoff. We will be hearing argument this morning via teleconference due to the ongoing pandemic. The rules for oral argument are the same as they are in person in our courtroom, 15 minutes per side with no rebuttal. The next case we will hear is number 19-1745, Ramasarin versus CARROZZA. And we will hear first from Mr. Kelly.
Good morning, members of the panel. May it please the court, Peter Kelly for plaintiff appellant Dr. EDDISON Ramasarin. This appeal seeks to reverse a trial court order that granted absolute immunity to 2 members of the Board of Registration in Medicine. The trial court order dismissed plaintiff's complaint under Rule 12b-6, solely based on the role of defendants as board members. The trial court order ought to be reversed as it applied absolute immunity too broadly. Plaintiff does not seek to disturb the well-established principle and public policy that insulates from liability discretionary conduct within the ambit of prosecutorial or adjudicatory functions that are truly quasi-judicial. Rather, this appeal seeks to allow prosecution of claims that arise from conduct that is best analogized to the rogue police officer or detective that plants or fabricates evidence against an individual.
Okay, so can you tell me, let's say I agree with you that if the defendant CARROZZA, and I guess the liability of Sloan is derivative of his, so let's just look at CARROZZA for a minute. If CARROZZA was acting not in a prosecutorial or adjudicative function, but an investigative function, perhaps he wouldn't be entitled to absolute immunity. Although if he was acting in a prosecutorial or adjudicative function, even assuming he was doing it in a wrong or outrageous way, because that's what he's immune from suit about, he is entitled to absolute immunity. We're looking at the complaint because it's a motion to dismiss. Tell me precisely what acts he undertook that were not prosecutorial or adjudicative according to the complaint.
I believe I can direct the court to paragraphs 35 and 36, and then 79, 80, and 81. And I believe what is demonstrated in those portions of the complaint are references to Dr. CARROZZA as an investigator working in a capacity for the Board of Registration in Medicine.
So, Counselor, by paragraph 35, the board expert has evaluated this, has found enough misconduct to recommend a 2-year probationary period, and Dr. CARROZZA analyzes that and decides that it needs to keep going. Why is it any different than a prosecutor having a detective come and say, here's the charges I think, and the prosecutor saying, well, I think we need to look into more serious charges based on what you found? Why is that any different?
Well, I think the second layer that's involved here is as a covert expert, which is prohibited.
Okay, but what if I, as a prosecutor, an expert comes to my detective comes to me and says, here's what I think we should do. And I say, hey, you know, I know a lot about computers, and I think it's a more serious charge based on my knowledge of computers. Why am I still not acting as a prosecutor?
Well, that's, as Your Honor describes, is making a recommendation. What the plaintiff is complaining of in this matter is that Dr. CARROZZA used his expertise in medicine and determined that there were violations by the plaintiff that warranted further action. So it was not evidence that was then recommended. It was the process. I'm
No,
sorry.
go ahead. Sorry. You don't let me interrupt you. Go ahead.
I was saying it was the process of Dr. CARROZZA, and it was acknowledged by the board attorney that what drove the process was the underlying opinion of Dr. CARROZZA. So that is separate and apart.
Okay,
from a
but let's say a
recommendation.
prosecutor, let's say, I mean, maybe this is just Justice Ditkoff's question. Let's say a prosecutor or a judge has personal experience with some set of facts. I used to be a professor, for example, and we get a case before us, and the case is about how a university operates. Now, I'm supposed to stay within the record, and I assure you I do, but let's say I wrongly brought in my personal knowledge. I turned to my two colleagues and I said, you know, the allegation is X, but the truth is the provost of a university would never do that. That might be wrongful, right? But I'd still be acting in my judicial capacity wrongfully. So even if this, and I don't think it's anything like that clear case, you want the board of registry to have trained physicians on it. It may just be your client's bad luck that a member of the board was trained in something close to his own subspecialty. But I don't understand how you stop being a prosecutor or a judge for that matter because you wrongfully bring in information you know. To me, it seems you keep calling it like covert expertise, like that's a thing. And all I'm saying is, yeah, maybe he went beyond the record. I don't know that a prosecutor, for a judge, that would be wrong. I don't know that a prosecutor can't do that. What's your response?
My response is that the consideration that ought to be made in that scenario is whether the individual is acting outside his sphere of duty. And I would submit that the cases Arthur's, Morris, DeMoore do prohibit the board of medicine or a board from relying on a shadow or silent witness. So we describe Dr. CARROZZA as a covert expert, but what equally applies is describing him as a shadow or a silent witness, which is prohibited.
Yes, but if he's doing it in his capacity as a prosecutor or an adjudicator, he's absolutely immune, even if it's wrong.
Well, as a prosecutor or adjudicator, I agree, Your Honor. But we are asserting and established by the complaint that the wrongful conduct occurred in the investigatory stage. And the board has provided no guidance to the court or its case to the court that allows in the investigative stage an actor to engage in conduct as Dr. CARROZZA did.
My understanding is that pursuant to regulations, there was some kind of hearing at which your client appeared and was questioned aggressively by Dr. CARROZZA. Is that right?
That was in the chronology of occurrence.
You're not talking about that. That's not the investigative piece you're describing, because was that, I take it that's in the regulation, part of what in their prosecutorial or adjudicative function the board does. They hold such hearings. Is that right?
Well, there had been no, that was prior to the 30A or the show cause. That was whether to initiate inaction. And there was discussion and then it was referred back for further investigation. But again, as far as the groundwork on which the plaintiff relies, doctor or the board properly engaged an expert to review Dr. Ramasarin's medical care. The plaintiff asserts that the board in effect ignored its own expert, Dr. Schwerk, and Dr. CARROZZA's opinions about the matter supplanted the board's expert. And that again was in effect, he provided evidence for sufficient cause to exist for the board to then act on the complaint committee and further issuance of a 30A statement of allegations. So the time frame is critical, and looking at all the cases, the time frame is critical. The plaintiff's complaint, first amended complaint, lays out and asserts conduct that occurred prior to what the case law provides as protected behavior. It occurred prior to prosecutorial or adjudicatory actions.
I have a different question, and that is, does Betancourt address the issues that you're raising in your brief? And if so, are you arguing that this case is distinguishable or that Betancourt was wrongly decided?
Not that Betancourt was wrongly decided, Your Honor, distinguishable. And the reason for that is simply the Betancourt issue was accepted as true that the behavior was quasi-judicial. So that court did not address what we are addressing in our complaint and in this action. So it was not decided one way or another because the plaintiff in that matter acknowledged that there was conduct that was quasi-judicial. And we expressly reject that Dr. CARROZZA's behavior was quasi-judicial as it being in the investigatory stage.
Would you agree that the court in the Betancourt case held that the judicial or quasi-judicial function and the adjudicatory functions and prosecutorial functions for that matter are to be broadly construed?
Broadly construed, but the burden rests with the defendants to demonstrate that their behavior is within the quasi-judicial realm. And again, this was a Rule 12b-6, and the only instruction of the trial court was in the performance of their role at the Board of Medicine. And that is insufficient as a basis to then dismiss this action at that stage.
Am I right in thinking that unless it is either malicious or unconstitutional for a member of the board to rely on their own medical expertise, that you don't have any sort of case?
It is not, if I'm understanding, Your Honor, we are not required to show in terms of defeating absolute immunity that it was malicious.
But to have a case, to make out malicious prosecution, intentional interference, or a 1983 suit.
What the elements would require is that there be no, our obligation to show under malicious prosecution, there was no probable cause, which rests on our argument that it was essentially Dr. CARROZZA's coming up with his own evidence that it was with malice, and that the matter ultimately resolved in Dr. Ramasarin's favor. So we feel we satisfy those elements. And on the tortious interference, that he had an advantageous relationship, that there was deliberate interference by Dr. CARROZZA as a shadow or covert expert, and that that was the improper means is doing that. And there was financial harm, economic harm to Dr. Ramasarin. So those elements of tortious interference are satisfied. if there are any other questions, otherwise plaintiff will rely on his brief in this matter, and thank you.
Excellent. Thank you very much. I see no further questions. Very well briefed and argued. We will hear now from your brother, Attorney Boudou.
Good morning, Your Honor. Thank you. Jesse Boudou, Assistant Attorney General for the defendant appellees. I'd like to start, if I could, with my brother's argument about covert expertise. As a matter of administrative law, it is ordinary and appropriate for an administrative official to look to their own expertise and knowledge in the course of making an initial charging decision. When we look at the case law that the plaintiff is relying on here, Arthur's, Morris, Demores, those are cases that arise in the context of final adjudicatory decisions under Chapter 30A. In that context, I would agree. It absolutely goes without saying that an administrative official can't rely on their own expertise and is bound to the facts in the administrative record. But that rule does not apply in the discretionary charging context, where decisions by their nature have to rely on both evidentiary and non-evidentiary factors. So in these regards, I would just point to a few authorities. The SJC's decision in Miller, which is cited in our brief, a case not cited in our brief, DeChico versus Department of Environmental Protection from this court in 2005, 64 Mass Appeals Court 423. That decision in turn looks to the Supreme Court's decision in the Heckler versus Cheney case, which I think is one of the seminal decisions in this area. And finally, I would point to pages 96 and 97 of the record appendix, which is where a Superior Court judge in the context of the 2015 lawsuit brought by the plaintiff rejected the same argument made here and pointed out the mistake in the plaintiff's argument, that mistake being a conflation of the rules that apply at the adjudicatory stage with the principles that apply at the charging stage. Justice Ditkoff, to your question, I do believe that the plaintiff here acknowledges in the brief that the nub of the complaint and the real essence of all three alleged causes of action is that Dr. CARROZZA acted as a quote unquote covert expert. So if that proposition is incorrect as a matter of law, then the case would be straightforwardly resolved as a 12b6 matter. But I'll turn then to the primary absolute immunity issue presented by the appeal, which is whether the principles of the Butts and Betancourt cases protect the work of Borum's complaint committee, and we submit that they do. The Supreme Court decision in the Butts case tells us that administrative officials, just like criminal prosecutors, are entitled to immunity with respect to the initiation of enforcement proceedings. And that function is the one that Dr. CARROZZA performed as a member of the committee in this case. Now, when the committee was handed this case by the investigator, who had already performed a nearly 3-year investigation into the matter, the committee's functional obligation under the regulations was, in essence, to decide between two choices. It could decide based on the evidence that no charge was warranted, and it could close out the case and dismiss it, which it could do on its own. Or it could decide that a charge may be warranted, and it could make a recommendation to the full board to that effect. And that is the course that the committee took here. And both for making that recommendation and for the evaluation of facts that went into that recommendation, Dr. CARROZZA is entitled to immunity. Now, Justice Ditkoff, you offered a hypothetical earlier, and I'll put a slight twist on it. We could imagine in the criminal context an ADA being handed a case file. The police officers have already spoken to the victim, investigated the key witnesses, and the ADA is deciding, should I take this case to the grand jury or not? I think it's borderline. I'm not sure what to do. And as part of that consideration, the ADA says, you know what? I have to talk to the victim myself, or I have to talk to the key witness myself. Now, that kind of interview would be certainly a type of fact collection, but it would be fact collection for the purposes of making the charging decision. And the case law, Chicopee, Van de Kamp, Imbler tell us that that would be immune. And so I do think that that hypothetical really captures the essence of what happened here. Dr. CARROZZA was responsible for evaluating a case file that had already been developed for a nearly 3-year period and making a charging recommendation, and he should be entitled to immunity to the same extent a prosecutor would be in analogous circumstances. In all other respects, Your Honor, I'll make one final point. I won't address our alternative arguments in detail, except to say that there's an argument made by the plaintiff in the reply brief that the court cannot reach the alternative arguments here in the absence of a cross appeal. I would suggest that's incorrect because the judgment here was fully in favor of the defendant appellees. The court can affirm on any grounds supported by the record. The SJC's decision in the Fay case would be one example of that, which is cited in footnote 12 of our brief. And another example would be the SJC's decision in Breer versus Fagan, 447 Mass 68 decision from 2006. I would be happy to answer any questions the panel may have today, but in other respects, the defendant's appellees would rest on their brief.
See no further questions. Thank you very much, Attorney Boudou. Very helpful to us. Attorney Kelly, thank you. The case is submitted.
Just a moment. The case is now being recorded.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. I'm joined today by Justice Neyman and Justice Ditkoff. We are hearing oral argument by teleconference in light of the ongoing pandemic. The rules for oral argument in the teleconference are the same as those in our courtroom, which is to say 15 minutes per side, and there is no rebuttal. The next case we will hear is number 19-1572, French versus Smith. And we will hear first from the pro se appellant, Ms. Smith.
Thank you, Your Honor. May it please the court. My name is Michelle Smith, and I am one of 10 appellants representing myself pro se in consolidation with the other 9 appellants. Appellants would like to reserve 2 minutes of rebuttal time. However, I just heard you say that there's no rebuttal, so thank you. This is a case of libel defamation. The issues in this case are the subject letter of the case had already been adjudicated in a quasi-judicial hearing. There are 14th Amendment issues of due process invoking violation of the litigation privilege. The subject letter had a qualified or conditional privilege and was protected under the First Amendment. Due to First Amendment protections, the Noer-Pennington doctrine was violated by appellee's claim of interference with contractual interests. The judges and the jury's misapprehension of issues leading to decisions that were inconsistent and against the law, denying defendants or appellants a fair and impartial trial.
Can I ask you one question? I'm sorry to interrupt, Ms. Smith.
Yes.
So these 3 arguments that you've just made, legislative privilege, Noer-Pennington, and the First Amendment argument, which I take it as an argument that the so-called actual malice standard should have been applied and that a judgment should only have entered in the event that knowing falsity or reckless disregard of truth or falsity had been proven. I think we do not have a full transcript of the trial, is that right? So you can answer that, but I'm wondering whether any of these arguments were made during the trial.
The majority was made within our 60B motion.
Yes, but during the trial, I'm asking.
The trial, we had counsel. He did touch on the First Amendment, but unfortunately, he didn't do a, fantastic job.
So these things were not raised until the 60B motion. That's the first time that you raised these?
Yes, other than he did also raise that the appellee should have been deemed a limited public figure. And the judge, I understand it that that's a question of law, and the judge never ruled on that.
The judge never ruled on. Do you have, do we have the part of the appendix where counsel raised that?
Well, that was also raised, kind of in passing by our counsel, because unfortunately we had an incompetent counsel, and that was raised significantly in the 60B motion.
No, I understand, but I'm interested in, you say that he mentioned it at trial and the judge didn't rule on it.
Right.
Is that because he didn't really make a motion about it? He just mentioned it, or did he ask the judge to rule on it and the judge never did? That's
in his arguments, he just touched upon the limited public figure, and the judge, as far as I can see, never made a ruling on it because Mr. French, the appellee, was never given the designation either way.
And when you say he touched on, do we have pages of the transcript before us where he does that? Because I know we only have some limited pages of the transcript. I don't know if you know the answer to this. I'll also ask Attorney Pinero. She may be more familiar with the record.
I don't know, because like I said, I remember it as a fleeting argument of our attorney raising it, and then there was nothing ever that came of it. So I pursued it on the 60B motion.
Okay. Please keep going.
Okay. Another issue is the venue transfer issue, which was based on an elementary mistake. And then the anti-SLAPP denial, the judge's intemperance, the trial judge's intemperance, denial of motions for the directed verdict, JNOV, and the 60B motion without a hearing. Appellee counsel's continued violations of candor toward the court, violations of rules of professional conduct 3.3. The case should be deemed a case of first impression under the 2018 Act of Congress called the Safe Sport Act. Okay. In 2010, all appellants had minor daughters aged 12 to 16 that were athletes within the appellee's amateur softball organization called the Bay State Blaze. Upon witnessing and hearing emotional and frightening complaints from our daughters.
Take your time. It's okay.
Over the course of the 2010 softball season, all appellants were compelled to remove their daughters from appellee's organization to a new softball organization. Appellant sent a letter of complaint on August 24, 2010 to the National Governing Body of Softball, the Massachusetts chapter. In October 2010, the Mass chapter of USA Softball, the National Governing Body of Softball, conducted a hearing where the appellee, who had legal representation at the hearing, testified under oath. Appellants Michelle Smith, Sharon Hurley, Kelly Dickerman, and Sean Reed testified as well. The Mass chapter of USA Softball suspended appellee for 5 years based on the allegations in the subject letter of this lawsuit. Appellee appealed the decision to the National USA Softball Organization, who upheld appellee's 5-year suspension. On August 23, 2013, appellee filed this claim in the improper venue of Suffolk Superior Court. Appellants put in a motion to dismiss for improper venue. Instead of dismissal, the lower court transferred the case to Norfolk Superior Court in May of 2014.
Is there a reason that you say that's improper? Why can't the judge, if the venue is wrong, instead of dismissing, transfer it to the proper venue?
Because of the, in the case of, I think it's Cote versus Waddle, it set the precedent that it's not in the interest of justice to, you know, transfer a case that in order to save it from being time barred. And under federal rules, I think it's like four. I'm getting to the part. I don't know.
We have your brief, so we have all these citations.
Okay. Yes. Yep. But any event, for an elementary mistake, it doesn't qualify under those statutes for it to be transferred. It calls to be dismissed, and defendants asked for it to be dismissed, but instead it was transferred. So this claim was also filed one day before the running of the statute of limitations, before the 3-year statute. Should I continue?
Oh, please, yes.
Oh, thank you, Your Honor. Okay. Okay. I'm sorry. I kind of... Superior Court. The case became stagnant and appellants were continually misled, not informed or misinformed about the status of the case by their counsel, Edward Joyce. Appellants had no idea until after trial that both counsels had continued the case a number of times, yet neither were appearing in front of the Supreme Judicial Court. And we weren't abreast of any of the continuations or anything. I mean, this languished in the court for 5 years before it came to trial. In 2017, appellants filed an anti-SLAPP motion that was denied. The case came to trial in June 2018. Appellants were surprised on the first morning of trial that their counsel had not subpoenaed any of the witnesses that were supposed to testify on appellant's behalf. The judge's tone of intemperance toward appellants was displayed almost immediately and continually throughout the trial. The jury returned an inconsistent yet adverse verdict upon appellants. Appellants filed directed verdict, a JNOV motion and a JNOV motion that were denied. Appellants filed a notice of appeal, and their appeal was documented in January 2019, given the docket number 2019 P133. On June 4th, 2019, appellants filed a motion to request leave in the appeals court to file a 60B motion in the lower court. Appellants filed their brief on June 18, 2019. Appellant's motion was granted for the 60B motion on July 1st, 2019. Appellant's 60B motion was filed in the lower court in July of 2019. The lower court denied the motion without a hearing on October 16, 2019. Appellants immediately filed a notice of appeal and docketed their appeal on October 30th, 2019. The appeals were enjoined and given the docket number 2019 P1572. On November 26, 2019, appellee passed away. Appellee's counsel did not inform the court of his passing until February of 2020, all the while filing motions and appellee's brief on his behalf, despite the fact that counsel's representation ended upon appellee's death since he died intestate. Appellee's son did not apply to be named personal representative of the estate until March of 2020. He was named personal representative on May 11, 2020. So from November 26, 2019 to May 11, 2020, as far as I understand it, counsel's representation of Mr. French appellee ended upon his death, and he did not have a will naming a personal representative. He died intestate. And so the representation was over. It didn't automatically transfer to his estate because he didn't have an estate until May 11th. And so all those months, appellee's counsel was essentially fraudulently putting in the brief on his behalf and any motions that were there without a representation of a client. And to me, I interpreted it as because she has a very viable interest in this case, you know, as far as taking it on a contingent and everything. And that's supposed to be a no-no as far as counsel to pursue, you know, a case because of your financial incentive with it. And that's kind of the violation of the professional conduct rules that I had alluded to. So should I continue?
Well, you only have a minute left. And
Okay.
I do want to make sure that you tell us everything you have to tell us. We've read your brief with care.
Okay.
Let me also say this just to make sure you understand it.
Yeah.
In an appeal from a civil case to our court,
Yes.
this isn't the forum exactly for complaining about errors made by your lawyer. To a large extent, almost completely, we have to look at the record below and see how the case was litigated there. And so to the extent that claims are based on your lawyer's failure to do X or do Y, we are stuck with a record in which he didn't do X or do Y. You see what I mean? And so, I mean, I understand that that may seem unfortunate and unfair, and I'm not saying your lawyer did anything wrong either. I have no idea. Maybe he's the greatest ever. I have no idea. Because I really don't. None of us, you know, we don't know that. All we can see is what we have in front of us. But some of the claims, you know, I asked you at the beginning, did he raise X, Y, Z? Because if he didn't, and the court below didn't know they were the issue, then we can't say the court did something wrong when it was because they weren't asked. That doesn't cover all of the arguments that you're making, but many of them have this piece of it. And I just want to let you know, sort of so that you can hear and understand it, that many of those things may just not be redressable in an appeal.
Okay. And
Understand what I mean?
Oh, yes.
Okay.
Yes, Your Honor. In my extensive research since I took this on, and I envy all of you for all the work that you put in and what goes into this. There's a reason apparently I didn't do this for a living.
Well, I don't know about that, but lawyers do have to go to school for a while.
Can I ask you a question? Your time's up, but I'm allowed to go past if I have questions. I saw in your affidavit that you consulted with Professor Carey and Chief Justice Armstrong before you proceeded. And I was wondering, what did you give them when you were consulting with them?
They got the whole trial record. They went over the whole trial record. And then, so they were kind of like appeal advisors. And I met with Thomas Carey a number of times, and once in the office, Chris Armstrong, Attorney Armstrong, Chief Justice Armstrong, I'm sorry, it came in a little later on. But any event, they just kind of advised during the initial stages, because I was just so lost, and I got his name from another lawyer. And so he had me send him the record. He went through the whole record and they did an analysis, and they said that some of the rights that were preserved, specifically venue, was preserved and, most likely the anti-SLAPP, because the lower court judge did make a decision on that. And then Attorney Carey, when it came down to it, his hands were tied because both of them practice with Hogan Lovells now and they don't have any say, and, to reduce their billable hours, their rate, and it would have just been astronomical, that, we couldn't afford it. So he recommended the other appeals lawyer that appellants got, Thomas Murphy. And unfortunately, after about a couple months of him, I paid him a retainer of $10,000 to take the case. And then unfortunately, after 2 months, his mother had a stroke and he was her only caregiver. So he had to refrain from taking the case. So hence I took it over and did the appeal.
Thank you.
Know how hard it is for non-lawyers to appear before a court in any circumstances. And of course, before an appeals court, it's complicated legal issues. You've done an excellent job of putting before us what your claims are. I think we understand them. Is there anything else you want to tell us, though, before we turn to Attorney Pinero?
No, I appreciate your time. Thank you.
Of course. Thank you very much. It's very helpful to us. Attorney Pinero, we'll hear now from you.
Thank you.
Maybe you could start by letting us know, has the appellee been substituted in this court?
Yes, they have been. We certainly start there. Once the plaintiff appellee had passed away, within a week to 10 days, I was notified of the death and was retained by the anticipated personal representative. It was over the holiday season, so I believe things got somewhat backtracked with respect to obtaining paperwork and other items that are necessary for the probate court. I did not represent Mr. French in the probate process.
But you have filed a suggestion of death or whatever is necessary and substituted the
That is correct.
So that we have before us a living party with an interest in the lawsuit.
Yes, I spoke to the clerk upon learning of Mr. Martin French's death. I did notify the clerk and explained that I would be filing a suggestion of death, which was eventually filed in February of 2009, I believe.
And am I correct that the entire transcript is not before us? Is that right? We don't have a full transcript, or do we?
It was my belief that the appellants had filed the entire transcript, but I may be in error on that. But I did think that the entire transcript was brought up to the appellate court.
Okay, we'll have to look in the file. I thought we only had pieces of it, but I may be mistaken. And is it your recollection that limited public figure, I don't know if you tried the case, but that limited public figure, was it not raised below at all? Or was it ruled?
I have no recollection of limited public figure being raised at any time from the filing of the case till the jury verdict.
And no instruction on actual malice was requested, is that right?
That is correct.
Okay.
And a quick review of the transcript that's on my computer. I see no reference in the transcript that limited public figure was raised.
I mean, we'll look whatever we have to double check, but I just, the two of you are more familiar with the record probably than we are.
And in fact, the only argument that was made that was newly raised at the time of trial was conditional privilege. There was never any issue raised with respect to absolute privilege or litigation privilege. And the judge did include conditional privilege in his instructions to the jury. With respect to the anti-SLAPP statute, this case had some delays in discovery, and the counsel for the defendants and myself had agreed to postpone things with respect to discovery. However, the anti-SLAPP statute was filed weeks before trial was scheduled to start in April. And it was that caused continuation of trial, and not because discovery was incomplete. Plaintiff was ready to start the case. And at no time.
Do you say that the anti-SLAPP motion was late filed? Or
It was late filed.
And not due to some mutual agreement between counsel that it wouldn't be addressed?
That is correct. And once the decision was made by the lower court denying the anti-SLAPP statute motion, at that point in time, no appeal was taken on that decision, and the case was allowed to proceed all the way through trial, which in essence defeats the entire purpose of having the anti-SLAPP statute. So, although the lower court referenced that the motion to dismiss under the anti-SLAPP statute was untimely, there were also additional reasons why that was denied. Number one being the ASA was not considered to fall into a governmental, legislative, or judicial forum, and was not even considered a quasi forum.
Was there an evidentiary hearing on that about the nature of ASA?
Yes, there was an evidentiary hearing on that. And there was discussion about what the ASA could actually do with respect to the allegations and defamatory statements that were made within the letter. And although—
Why aren't the state, one of the people to whom this was sent, unless I'm mistaken, isn't there a state school?
Yes, Mr. French was the softball coach and did some maintenance type of work, I believe, at Massasoit Community College. That was his part-time employment.
And that is a state school.
That is correct.
So why isn't that a governmental entity?
It is a governmental agency, and so was the Attorney General's office about that. However, in addition to those agencies, the defamatory correspondence was distributed and left out and talked about beyond the limits of those governmental agencies.
I understand those pieces of it. I'm just trying to figure out where if we reach the issue, just where the different lines are.
Mm-hmm. All right. So with regards to the 60B motion and the judge being intemperate, like many justices, they're hard on counsel. They challenge our thinking. It's done here. And Justice Krupp was fair. He chastised both trial counsel for the defendants, counsel for the plaintiff at various times and challenged our thinking. So I cannot say he was intemperate, and I cannot say he was not fair. He actually, after arguments being made to him regarding changing the jury instructions, he actually sided with the defendants. Regarding the jurors being confused, I think the jurors paid close attention to the evidence that was presented to them, and actually, in their jury verdict, considered each statement that the plaintiff was alleging to be defamatory and untrue, and decided each one of those statements individually, further showing that they were not confused and had asked questions of the judge as well. So I must disagree with the statement that there was any juror confusion based on the evidence. And I think that my papers speak for themselves with regards to the issues that have been raised. And I would rely on the case law presented within the appellee's brief.
Counselor, can I ask you some questions about your motion to strike?
Yes.
You moved to strike a bunch of documents in volume 2 of the defendant's appendix. All those
Yes.
documents were attached to the Rule 60 motion, is that correct?
Yes, it was.
All right, and then you also moved to strike the charitable organization complaint form to the AG's office on volume 1, page 64.
In the sense that there was numbers of markings on the documents that were included in appellant's briefs that were not present at time of trial.
All right, so the problem with your problem with the letter to the AG is the markings?
It was the markings, and also it was not allowed into evidence at time of trial.
What do you mean wasn't allowed? Was it offered?
It was, the plaintiff did want to offer the document into evidence. However, the judge considered it to be hearsay.
Was it marked for identification?
I believe it was marked for identification at one point, although I'm not 100% certain.
All right, and the other thing was the plaintiff's deposition, the excerpt from the plaintiff's deposition.
Yes.
Was that marked for identification or at any point attached to a filing in the lower court?
It was attached to the 60B opposition. However, I remember having brief discussions about Weymouth High School being included at time of trial with the judge and with the defense counsel. But I can't recall and don't believe that it was discussed during cross-examination.
All right, thank you.
I see no additional questions. Very well argued by both of you. Thank you very much. Of course, we have your brief, Attorney Pinheiro, and yours, Ms. Smith. The case is submitted.
Thank you.